What is a will? It's really just a letter to the court expressing your intentions and your desires as it relates to your assets. It provides instructions as to the care of your children and how they are to receive those assets. A will, though, only provides for what happens after you pass away. It involves probate court, which costs time and money. You see, normally an attorney presents the will to the court. The probate judge has to make decisions relating to the reasonable liquidation of assets and how they are to be distributed. In order to make good decisions, the judge needs time, and this all costs money. Sometimes, especially depending upon the assets, a big portion of the estate can be eaten up by the winding up of the affairs, the legal fees, the executor fees, and taxes. Sometimes, lawyers will use a will because it is cheaper to create and therefore convince clients to retain them. But it also leads to much greater legal fees once the estate is probated. Most estates are probated by the lawyer who generated the will. It is a multi-billion-dollar industry. Probate is a public proceeding, so there are records filed with the court, making it far more public than the revocable living trust solution. A will, by definition, cannot provide for lifetime incapacity or disability. As a result, if you experience a lifetime disability, like Alzheimer's, your competency becomes the subject matter of a conservatorship proceeding. With a revocable living trust, you make decisions as it relates to the rules that take effect during periods of disability. You can even establish rules that come into play in order to regain your competency without having judicial involvement. While a revocable living trust is more expensive than a will to create, comparing the cost of probate to the cost of administering a revocable living trust, it is normally far less expensive in the long term. You avoid judicial delays and costs associated with having the affairs of the estate wound up, because the person you name to handle your affairs simply takes over as trustee. It is a very private proceeding and generally requires very little, if any, judicial intervention. If you need help, please reach out to Christopher S. Nudo, attorney at law, today.